All right, welcome back to LevelEsq podcast, Trials and Tribulations. This is a continuation from our last episode. We touched a lot last time on some of the problems that have arisen both in litigation finance and litigation insurance, the resistance that has come from the defense and from the insurance companies. And we did touch briefly on what was going on with Level Insurance, but we didn't get into it much. So today, we're going to talk a bit about what happened and why Level Insurance is currently not available and what we expect moving forward in the future.
All right, so what happened?
All right, so that's usually the intro part. Right? I was giving them time to put up all the graphics.
No, what's interesting, we intended to get to this topic last time we spoke last week, and one of our customers emailed us and said, "Hey guys, I appreciated your last podcast. I agree with the views that you expressed, but what the hell happened with the insurance, with Level Insurance? What's going on now?" You never got to that part, so we discussed it last night. We're like, all right, we got to get back on the microphone this morning.
It happens, we start talking about one topic, we veer off, and we forget.
Yeah, but it's all related.
So Level Insurance, for those that don't know, it was the first ever, and it remains the only ever insurance that covered plaintiff lawyers' litigation expenses. So if a case went to trial and the case was lost at trial, all of the money that a law firm would have invested in all the expenses like expert depositions, trial transcripts, travel, filing fees, everything that you would otherwise pass on to your client, you could get reimbursed if you had this insurance. And it was difficult for us to get it to market because it had never existed. Larry and I invented it by thought back in 2011. We spent a tremendous amount of time to figure out whether it was marketable, whether an insurance company would ever even supply the paper for the risk. And after 4 years of hard work, we finally brought it to the market in late 2015, early 2016.
But it's interesting because it was a new concept, new idea, no track record. We got it done. Yep. We faced a lot of obstacles, which we're going to discuss today, but it was an idea still at this point.
Yeah.
Fast forward to today, it's no longer an idea. It was a successful insurance program with a proven track record, and it was a profitable business. But despite that, we are where we are today. So let's explain to our audience and to our customers the struggles that we've been facing.
Yeah, so we came to market in I think it was actually 2016, not 2015.
July 2016.
And since that time, we've sold thousands of policies to hundreds and hundreds of law firms throughout the country. Firms
including Alaska, Hawaii. Shout out to Tim Choate in Hawaii. It's something that we're very proud of. We have a national footprint.
Yeah, and so we were able to, and this is all done by word of mouth. So we did everything through going to conventions, speaking with our colleagues, and we ended up insuring hundreds of millions of dollars worth of litigation expenses very, very successfully. And the program was very popular amongst trial lawyers. But of course, when something gets popular, it gets more well-known, there's more scrutiny placed on it. And that's sort of what happened to us. In the early stages, I think that our program was so small with the insurance carrier that was providing us the backing that it sort of slipped under the radar.
We were always under the radar, and it seems that that's just where our partner was comfortable with us being.
Right, because if it got too big or it got too well-known, then perhaps some of the insured parties on the other side of the defense, whether it be hospital systems, big corporate clients, huge, Fortune 500 corporations,
or other executives within the company who feel very strongly against what we do. Again, just like we were talking about last week, it's right. That same bumping up against that same force that's in the background.
Yeah. So the second that it became more well known and more scrutiny was placed on it, obviously a lot more questions started getting asked. At the beginning of the program, from 2016 through about, 2020, 2021, every policy that was sold was done without any questions. It was done immediately online. It was very efficient, and that's why customers liked it. But beginning in around 2021, we started getting more questions from the insurance carrier that was providing us the backing. They wanted to know more about larger insurance policies. They wanted to know more about individual plaintiff lawyers. They wanted to know more about the timing of the policies and when they were being sold. So we started getting a lot of questions, despite the fact that the program continued to perform remarkably well. It gave a great service to our clients while also providing a tremendous amount of profit to the carrier that we were doing business with. But of course, as it got larger and more popular, all those questions started getting asked, and then we ended up where we are, or we ended up last year, which you can kind of explain.
Well, there's a lot of things going on. And again, we have to be very careful about what we say. And I want to make it clear that the partner we worked with was very supportive in the beginning, and we're still very grateful for the opportunity that they gave us. But it's still a carrier involved in the industry that's notoriously hostile towards plaintiffs' lawyers. So at a certain point, there was a breaking point, we'll call it, when the Florida tort reform, this last round was passed in March of last year. It sent shockwaves throughout the insurance industry. In particular, there was an open memo written by the Morgan & Morgan law firm, which is the largest plaintiffs law firm in the country, and essentially declared open warfare against the defense bar. It was a very controversial memo by design. It was meant to be very aggressive and antagonistic, and it worked. And it created a lot of discomfort amongst the defense bar and amongst the insurance companies. And when that memo was circulated, I think it was leaked, but it really wasn't.
Yeah.
It was meant to be published. And that set off a chain of events that led to ultimately to our program being discontinued by our carrier partner. It was very disappointed. We understood, I suppose, where they were coming from. It was always something that was a risk that we faced, that somehow the program would get too big or become too controversial. And that's what happened. And again, what makes it very frustrating is that it was a sound business. It was a good business, a good program. Everybody was happy. Our customers were happy. The carrier was happy. It performed as intended. It was profitable. Despite that, it was discontinued.
And even more importantly, I think, is that when that memo came out from Morgan & Morgan, which declared that open warfare on insurance companies and defense lawyers. And for anybody who hasn't read it, we can put a link in our bio here. Basically, what the memo said was, if that tort reform was going to be passed, then Florida lawyers, or any lawyers, would not be negotiating at all with insurance companies anymore. And any defense lawyer who represented insurance companies was somehow a horrible person.
No extensions, no professional courtesies, nothing. Scorched earth.
And listen, if you're thinking about it, tort reform in Florida, the most recent round, pretty much destroyed the property litigation side. So first party property.
Yeah. I think if you could put a link here to that podcast episode to really lay the context out.
Yeah, we talked about first party property pretty much being destroyed here because attorney's fees were ended, and it made it very difficult for any homeowner who had a problem from like a hurricane or a storm to really get recourse, because smaller damage claims would never be taken by lawyers because there wasn't enough fees there to pay for their fees plus recover for their clients. And obviously a firm like Morgan & Morgan, who has a huge property division, would have suffered economically.
From what we understand, they had to let go, I think, hundreds of people.
That's what we heard.
Yeah.
So that memo, though, was not necessarily the feelings of all plaintiff lawyers. In fact, we talked to many plaintiff lawyers who were upset that it was sent out because it put them in line with that line of thinking, even though they still had very good relationships with adjusters and people on the insurance side.
We're all colleagues at the end of the day.
Right. And they didn't hate their defense lawyer colleagues. Not. These are people that they were friendly with that now all of a sudden they were pitted against because of the power and the breadth with which this memo was sent out. It's funny, Larry, if I could go off on a little bit of a side tangent. When I first started my own practice, and I'm not sure if anybody else who's done something similar has heard this, I remember going to one of these law firm cocktail events, and it was for something like either the Miami-Dade Trial Lawyers Association or the FJA, one of these.
I always used to like those. You always.
I hate them, but I went to them because you had to start meeting and greeting people when you start your own practice. I must have heard from 10 to 15 different defense lawyers independently during that one event. Please sue my clients. Congratulations on starting your own practice. Make sure you sue my clients. Why? Because that's how they make their money.
Of course.
They make their money when their clients get sued by people like us and they bill them. So the inside feeling amongst the defense bar is, plaintiff lawyers, please sue our clients. On the outside, though, they have to take this position where they're supportive of the very thing that's going to destroy all of our business, which is stuff like tort reform. Right. So I digress a little bit, and it analogizes a bit to the way our own business and Level Insurance was working. Everything was going smoothly. Nobody was getting hit hard with losses. Our colleagues that needed the coverage were getting it exactly as we had promised it. It was the perfect catastrophic coverage.
The fundamentals work. We created a risk pool it was priced fairly and appropriately.
Right.
So all the fundamentals of a successful insurance program were met. And I think to this day, we're very proud of that.
Yeah.
We took it from an idea to a functioning insurance program where the fundamentals were met and it was profitable, and we had happy clients who found utility in the policy.
And anybody watching this who's ever had a claim with Level Insurance will know that those claims were paid immediately. They were paid in full. There was no argument. There was no red tape. It was done exactly as we promised it would be done. And that's a testament also to the carrier that we worked with, because they did exactly what they said they were going to do.
But let's fast forward now. So that's essentially what happened.
Let's at least, hold on, just so we're clear.
Yeah.
It's our opinion that that's what happened.
It's our opinion. Yeah.
It never was said directly to us that this whole tort reform was the reason why the program was discontinued. We were just told that the program was going to be discontinued.
And that was about it.
And that was it. But it was a cascade of events that occurred following that memo.
Right.
So it's our belief and our opinion that it was discontinued, at least in part because of some political blowback that occurred as a result of the insurance carriers being labeled as being the enemies of all the people by the Morgan & Morgan memo. By the way, no blame to Morgan & Morgan. They have every right to say what they want to protect their own business, and we don't blame them at all for what happened. It just so happened that memo was followed by some events that led to the end of our program.
That's it. That's us interpreting what happened. But I think what people have been asking us, and we're still receiving emails every day from our clients, what's going on? Is the program back online? Give us an update, an ETA. And I think what we've been going through over the last few months, going back into the insurance markets to find a new home for the program, is even more interesting. And I mentioned earlier in our conversation that in 2014, 15, 16, this was an idea. It was a concept, well thought out and researched, but it was still just an idea. Now, it's a business with years of track record. And despite that, and demonstrable profits, despite that, we've had extraordinary difficulties finding a new carrier to back the program. And I think that's very interesting, and people are very curious what we've been going through over the last few months. And I think now's the time to share some of our experiences.
Yeah, so what's interesting is that whenever we talked, and there's a limited pool of insurance companies that would be able to do this.
That do specialty programs. Right.
You're not going to go to the massive insurance carriers that do auto and homeowners. They're not the right ones.
Right.
There are carriers that do things like when you go to a basketball game and somebody takes a half court shot, that's insured. So if they make that shot and they win $1 million, the basketball arena is not paying it. The insurance company pays for it. So there's
in insurance parlance, it's called a program or a specialty program.
Right. Something that's a little bit outside of the box.
Right.
And that's what our program was, something outside the box. And so we've gone to certain carriers, and every carrier that we have met with has been excited about the opportunity to do this program. We've gone and met with people all over the country, sat with very high level executives, and they give us the impression that this is something that they absolutely want to do.
Yeah, the people who are the executives, then we meet with the salespeople, and then it has to undergo underwriting scrutiny. So the actuaries take a very hard look at it and go through the data, go through the performance. We've been able to get through all of those initial layers with several partners who were very interested. But then what happened?
Then somebody somewhere who's unnamed, sitting in some dark room, who doesn't like plaintiff lawyers, doesn't like you if you're a plaintiff's lawyer, doesn't like us, decides that they simply cannot do anything to support the plaintiff's bar. The plaintiff's bar is evil. They are trying to raise our insurance premiums. They are trying to make it difficult to get good medicine. This is their thought, of course, not ours. And as a result of those thoughts and those prejudices, that one person who sits higher up than any of the people that we're talking to completely nixes the program. And we get some phone call or email that says, hey guys, we love the program. Unfortunately, we are not going to be able to proceed.
Some executive on a golf course, God knows where, found out about this and said, hell no.
And we never hear from those people. They don't ever have, I don't know if it's the decency, the guts, the balls. They never actually call us and tell us, No one tells us. By the way, we lost a little bit of light there, so if we got dimmer, it's just to make us look a little bit tanner. But we don't know who these people are and why they keep saying no. We surmise that it's because they dislike the idea of providing any help to the plaintiff's bar. But we are not done, and we've been continuing to work, and we will continue to work. And so for anybody out there that is wondering if this program is ever going to be back, Number one, I'll tell you, you should have bought all your policies before the program was over. We warned you. But we will be back, and we're going to keep working with whatever insurance carriers will listen, and we'll set their prejudices aside, whether that's in London, because London is a robust market for insurance that may not have the same level of prejudice that people here in the United States do.
We've made a lot of progress there recently.
Yeah, and so that is our goal. Our goal, just so anybody who works with us or has worked with us knows, this program has been fantastic for the plaintiff's bar, and it will again be fantastic for the plaintiff's bar. We continue to, of course, do our loans and offer our financial products to lawyers and to small businesses. But for Larry and I, although this product was not wildly profitable necessarily for us, it did okay for us, but our other businesses have certainly done much better. We feel such a passion about doing this because it's rare that you ever are able to invent something. Everything's been thought of. And we invented this, and not only did we invent it, but we invented it for our colleagues, for the people that we respect, for the people we work with. And we feel so strongly that it is such an important risk mitigation tool for all of you hardworking plaintiff lawyers that spend your own money and risk your own time, that it's our obligation to bring it back to market.
And we will. It's an extraordinary source of pride for us that we brought that to market. I think it's, in many ways, it was a concept that was ahead of its time. We're looking now over the last, since we brought it to market, all the innovation that's gone on in the insurance industry as it relates to litigation finance and the likes. We were in the game first.
Yep.
And I'm very proud of that. We will not stop until this program finds a new carrier. It's been very difficult, but we owe it to our clients, we owe it to ourselves, and we owe it to our industry to continue until we find the right home for it. And I promise you, once we do, we have a lot of ideas how to evolve the program, how to make it even better, and we won't quit until we get that, until we succeed there.
And so I encourage anybody who has used litigation cost protection level insurance in the past, anybody who's interested in using it in the future, continue to contact us, continue to let us know. All that information is stuff that we use when we're working with other carriers to explain that demand is still there. It's still great. People who have used it before are still very interested in using it in the future. And the ways in which we want to change it and evolve it will make this program so much better for each and every plaintiff's lawyer out there.
But stay tuned. We will be very excited to announce when we finally do find a new home for the program. And we look forward to it, and we thank everybody for the ongoing support. And I hope that people find this interesting and they understand how hard we've worked in the past to make this program a reality, and how hard we continue to work to bring it back into the marketplace. So thank you.
And any questions or comments or thoughts about the program, you can always feel free to email either of us, Justin at LevelEsq.com and Larry at Level@ESQ.com. And we will be happy to speak with you about the progress and continue to keep you updated.
Thank you for joining us. This episode was sponsored by LevelEsq.